In the case of bonds, when setting a bond, what affects the amount? Do you just hear the case and say, okay, I'm going to give you the highest bond I most possibly can because I'm angry, or what, how do you do it?
The bonds in the state of Tennessee are governed by the Bail Bond Reform Act. That act has certain factors that we as judges are to consider when setting the bond. We do have a great deal of discretion. However, our discretion is governed by the legislature having set out that we are to consider a few things. One of the things we are to consider is we are to consider the fact that the bond should be set in an amount as low as possible, while still considering issues like likelihood of appearance in court, but also considering protection of the public at the same time. So after those factors are considered, there are then more specific guidelines in place, like ties to the community, family relationships, employment, any history of a lack of or a failure to appear in the past. All of those things go together for us to consider in exercising our discretion and setting the amount of bond.
Judge Steelman, when you have something that's come before you that's already been convicted of domestic violence, what is your tendency, how do you handle that in your decision of bond making?
Well, more often than not, a bond has already been set by the time I get a case. The bond is generally set on first consideration by a magistrate at the time of or shortly after arrest. That bond then will be or has an opportunity to be reviewed by the General Sessions Court judge or the municipal judge like Judge Wilson. And then by the time it gets to me, it's already then been reviewed. It's been set and then had an opportunity for review on at least one occasion. Oftentimes, by the time it gets to me, the grand jury has indicted, and the judge that presides over the grand jury, which is one of the 3 criminal court judges, will have also had an opportunity to consider the bond again. Bond consideration in the context of a case that's already pending, post-indictment with me, would be more in the context of a motion to revoke a bond or to increase a bond, and more often than not, an argument in that regard would have to do with the fact that there has been a history of violence and now this person is acting again violently, and that would go to the factor under the Bail Bond Reform Act of danger to the community, a specific danger to a specific victim. Very often, rather than making an effort to increase the amount of the bond, the first step by the prosecuting attorneys will be to ask us as criminal judges to impose specific conditions on the bond. That also occurs at the municipal and general sessions court level. A very common request is to request a no contact provision on the bond to restrict movement related to the bond. In certain instances, pretrial house arrest might be an option. Generally, in Hamilton County, there are restrictions in place where they are not going to take someone with an assaultive history on a pretrial house arrest unless we, as judges, see specifically that that would be appropriate for that particular case. I had something like that come up today, not in a domestic violence context, but in another context, where it made sense to me to order that because the person was obviously going to be in a position where they were entitled to have their liberty, but yet there needed to be certain constraints in place, one of those being that the community should be able to be aware of where he is or was going to be at all times, and house arrest is very useful in that regard.
Well, if I could add one thing, as Judge Steelman said, we generally set a lot more bonds than the criminal court judges, and every time that a person is arrested for domestic violence specifically, we have a form that has been, I guess, drafted by the legislature, and it's required to put in place for every defendant who is charged with domestic violence. It's called conditions of release. So in addition to whatever bond or bail amount you set, there is a checklist. There's probably about 6, 8 items on it. No contact with the victim. They can't go back to the house. Can't have a gun. Can't consume things, and so on. And so you put on this, you have to fill this form out. Usually the magistrate will do it. A lot of times I do it in Collegedale because that way we don't have to transport people downtown. But every defendant is given a copy of those, or supposed to give a copy of those when he or she is released. And a copy is also supposed to be given to the victim. And if you violate those, then your bond can be revoked and put back in custody. So that's kind of unique to the domestic violence. Is in addition to the bond amount, you have these specific conditions that a judge has to impose.